Welcome to When Do I Need to Go to Probate Court? Presented by me, Tina M. Patterson, Principal Attorney, Patterson Justice Council, PLLC. So, first of all, what is probate court? Well, probate court is a court that is specialized within the court system to deal with legal issues surrounding death and disability. Okay. So when someone passes away, now we need to find out what to do with their things, or when somebody is unable to manage their affairs now because of either a physical disability or a diminished mental competency or capacity. All right. So the following are three common scenarios of when going to probate court is necessary. First, when there is no one named to inherit. To inherit what? Some kind of asset. And let's get into it. Probate court is needed when an individual dies and has an asset, again, such as a home or a bank account or a car or maybe an expensive piece of jewelry or expensive artwork, maybe a stock, okay? Anything that can be owned by an individual, but it's only in their name. All right, so let's get into this example here. A widow has two daughters and she dies owning a home, her only asset. She had no will and she did not have any other estate planning technique to pass the home to her children. Because the house is titled only in her name and there is nothing set up for the house to pass directly to her children, her daughters must now go to probate court to inherit the home and gain legal ownership. Okay, so that is an example of when you need to go to probate court when there is no one named to inherit an asset. Second is physical or mental disability. Probate court may also be necessary when an individual becomes physically or mentally disabled and unable to take care of their daily living activities independently without assistance, and this is a process known as guardianship. Let's get into an example here. There's a father in a car accident, and his injuries cause him to lose the ability to use both legs. This disability makes it difficult for him to take care of his routine daily activities, such as grooming and bathing, as well as going to doctor's visits. Father may then ask wife to go to the probate court to become his legal guardian, so she can be granted the power to make health-related decisions due to his physical injury. Now we have guardianship here. There's also a companion process known as conservatorship, and that will serve a lot of the same scenarios, such as physical or mental disability, but conservatorship is more focused on taking care of financial aspects of the individual. So if they need to sell some real estate, they need to manage their bank account or business affairs, things of that nature. That's a conservatorship process, whereas the guardianship is more of the person themselves and their medical treatment. And again, that's number two of when do I need to go to probate court? When a physical or mental disability calls for it, and there's no other estate planning tool, such as a power of attorney, to handle those affairs. Okay, our third scenario here. When do we need to go to probate court? When there is an issue regarding the care for minor children. Finally, caring for minor children who have lost parents or whose parents have lost the ability to care for them may also need the probate court process. The petitioner, who is the person asking to be appointed the guardian or conservator, can use the process to become the child's legal guardian and or conservator. Example here. A single mother with full custody of a 12-year-old daughter dies suddenly in a tragic car accident. And this is a real life example, by the way. Now, without a parent, aunt, mother, sister can petition the probate court to become the child's legal guardian. Okay, so that is scenario number 3 of when do I need to go to probate court when there is an issue regarding the care for a minor child. Bonus. All right, I said 3, but I have a bonus one here for you. When do I need to go to probate court? To distribute according to a will. The most widely known estate planning tool, a will, documents your wishes for who you want to receive what when you pass away. Wills are effective tools for naming guardians for minor children or disabled adults whom you care for. Okay, in fact, only a will can name a guardian for your minor children or disabled adults that you have guardianship over. But wills are public documents and they must go through the probate court process to transfer assets and authority. Okay? Example, and we're going to go back to the example of the single mother here in our care for minor children scenario. So example, single mother with full custody of 12-year-old daughter dies suddenly in a tragic car accident. Mother had a will and named her sister, the child's aunt, to become the child's legal guardian. Mother also had a home that she left to her daughter. Using the will in probate court, aunt will be able to become daughter's legal guardian and secure the home for her to inherit according to the will. Okay, so that's the bonus of when do I need to go to probate court? When there is a will that you need to distribute and follow the process to do so. Thank you for allowing me to share this information with you today. I hope it helped. Again, my name is Attorney Tina Patterson, Principal Attorney at Patterson Justice Council, PLLC. To learn more, please visit our website, pattersonjustice.com, and follow us on social media. Thank you.